So Stuart, let's talk about litigating the case. We've now talked about how to set up your practice, some of the systems that are going to be necessary, signing up the case. Now let's talk about when you can't get that case settled after you send out that great demand letter that you're going to put together. Now we got to litigate the case. Why don't you take us through that?
You really need to decide what it is that you're suing for, what the cause of action is or causes of actions are, and who your target defendants are in the case. You need to make sure that you understand the elements of each cause of action. And what I mean by that is that you understand what it is you need to prove in order for a judge to charge a jury under that count in the complaint. You also need to understand the insurance coverages. And I'll give you an example. We have a case now, it's a very tragic case. We represent a mother whose 4-year-old son, starting at age 4, was sexually abused by another young man who was 10. And this came about because his parents were divorced, his father had remarried. When he would go spend weekends at his father's house, his stepmom's nephew would come over and he would sexually abuse this child. And this went on for years, even though the child reported it to his dad, who didn't believe him, reported it to his stepmom, who didn't believe him. And eventually it wound up with a criminal prosecution of the older child and severe psychological trauma to the younger child. When we had to draft that complaint, we had to be very careful because most homeowners policies have exclusions excluding sexual misconduct. And they also, in some states, there are limitations on a child's ability to sue their parent. In Florida, for example, a spouse or a relative could sue a spouse or a relative up to the extent of their liability insurance coverage. That's to keep the family intact. So in this case, instead of suing for sexual abuse or sexual assault, we sued the father and the stepmom and the parents of the young child who was the perpetrator for negligent supervision. It's claiming that because they weren't attentive and negligently supervised this 10-year-old at the time, these sexual assaults took place. And thankfully, we've been able to withstand motions to dismiss and motions for summary judgment. Had we couched the complaint in terms of sexual abuse, we would have been thrown out of court based upon the exclusions in the insurance policy. So it's very important to understand how to go ahead and get coverage by the way you craft your complaint. Not every automobile complaint is the same. There are certain basic formulas, as I said before, that you use in a form, but you've got to worry about jurisdiction. You've got to worry about venue. You've got to worry about who is responsible. And I'll tell you a little trick. In every automobile case where you have a truck involved, you have a driver and you have a company, normally, that he's working for. Many people would style the case Smith versus Jones and ABC Inc. The problem with that becomes when the judge ever calls the case, and you've got to think about this from the beginning of the case. I always look at every case as, how is it going to play at trial? The judge is going to say Smith versus Jones. He's going to leave out the ABC Inc. So when I write my complaint, when I draft it, I'm going to sue ABC Inc. as the named defendant first. So when the judge calls the case, it's going to be Smith versus ABC Inc. Because I want there to be a corporate defendant that the jury is going to keep hearing about. And I want that from day one in the case. So you've got to start thinking about those things from the moment you contemplate litigation. How it's going to play out in the end. who do you want the primary lead defendant to be in that case? Because that person is going to be number one when it comes to asking questions and depositions, but also number one when it comes down to the judge calling out the name of the case. So now that we've got that underway, we've got also, and we like to serve discovery with the complaint. We like to serve interrogatories. We like to serve requests for productions, sometimes requests for admissions, and sometimes what we'll do is we'll send out a notice of taking deposition ducus tecum of the defendant or defendants, or the person with the most knowledge from the defendants, with the complaint, setting it at a date about 60 days forward, knowing that that date is going to be changed because counsel won't be available, but we're doing that because we're setting a tone. We want to move discovery. As a plaintiff's lawyer, it's your obligation to move the case. The defense is under no rush usually to move the case. But if they see that you're actively prosecuting the case, they're going to give it more attention and more respect. And when we craft our notices for deposition ducus tecum, we also have to decide if we want to take a video deposition of the defendant. And oftentimes in cases we'll do that because I want them to show up, I want them to have them on video, and what we do then is we sync their video to their transcript, and for impeachment purposes, not only could a jury hear their words, but they'll see the demeanor of the witness, which is important. And if you have exhibits to show the witness during the deposition, such as photographs and things of that nature, and have them pointed out during deposition, it's much better if it's on video because it's clear to everyone. And I want to talk for a second about using videos in depositions and why I like it. And a key witness in a deposition, you can be sure that the witness will not be as prepared as they are for trial. They may not come dressed appropriately. I had a case where I represented someone who sued a Miami Heat basketball player. And the allegation was that it was New Year's Eve. This Heat basketball player was drag racing on a causeway in Miami, lost control of his Corvette, hit the center wall, the Corvette being fiberglass came apart. Some of the fiberglass hit my client who was on a motorcycle, knocking him off, severely fracturing his wrist. So I had the Heat player come to my office for a video depo. He showed up in a t-shirt and a baseball cap. Did not look appropriate for a deposition. He would have come to court in a suit and tie, to be sure. And then what I had my investigator track down his Corvette, and we found it in a body shop in Miami, and we photographed it. And I go through the testimony of the Heat player, and he tells his story about how the accident happened. And I say to him, how long have you owned the Corvette? And he tells me, did you buy it new? Yes, I bought it new. Did you have any aftermarket additions to this car? No. Are you sure? Yes. Did you have any performance enhancing additions to this car? No, never. We take a break. I then bring out an easel, and I bring out about 6 boards, 2 feet by 3 feet, blow-ups of photographs of his car, and I put it, and we go back on camera, and I put them up on the easel, and all of a sudden you can see the whole color draining from the Heat player's face. And I say, do you recognize what this is a photograph of? And he meekly says, it's my car. I said, well, can you tell me what this blue tank is? And he said, oh, yeah, that's nitrous oxide. And I said, what's that? He says, well, it makes the car go faster. I said, did you buy the car like that? Or did you add that to the car afterwards? He says, well, one of my friends added it. I said, well, didn't you tell me that you didn't add anything to this car to enhance the performance afterwards? He says, yeah. I said, so when you told me that, you weren't being truthful, were you? He says, no, I forgot. He says, but I never used it. It was in my car for 8 months, and I never used the nitrous oxide. I said, so you want this jury to believe that you had a car with nitrous oxide, you're drag racing on a causeway on New Year's Eve and you didn't kick it in at that time, needless to say, we settled the case for a lot of money. And the fact that we had this on videotape was much more important, because had we just been able to read this to a jury, it would not have had the impact and import in this case. There are also times when, and I'll get to that when we talk about mediation, when we use those video clips in mediation, but we'll talk about that a little bit later. So the complaint's drafted, the initial discovery is out, and the deposition's set. And at deposition, you don't want to go in there with a list of questions. Whenever I see a lawyer coming in with a list of questions, I giggle. Because you could be sure, as sure could be, that lawyer is going to go through that list of questions and check them off. And he's going to concentrate, or she's going to concentrate on that list of questions and miss the most important aspect of a deposition, and that's listening to what the witness has to say, and hearing what the witness has to say, and following up on what the witness has to say. And if you're too intent on your list of questions, you're going to miss what's going on. You have a court reporter there, you have a videographer there. Their job is to record what happens. Your job as a lawyer is to get as much information as possible and take it where you need to take it. And if you're not listening, if you're not hearing, you can't do that. So go in there with an outline if you like. Go in there with a couple of key questions that you need answered because your expert told you you need the answers to these questions. And by all means, if you have a complicated case, or if you have a case where you think you need to have some input from your expert on what to ask the deponent before you depose them, do that. Speak to your expert. Meet with them. Understand the science involved. Understand the accident reconstruction. Understand the vehicle dynamics before you go into the deposition. But make sure that you ask those questions, but make sure that you listen. The other thing is, don't take notes during the deposition. I never understood why lawyers write down witnesses' answers to every question when they have a court reporter. There again, you're losing your focus. You're not paying attention because you're too busy writing and you're not listening. Go back and read the transcript afterwards. Sometimes what I'll do is I'll have a paralegal, or I'll have my partner, or I'll have my associate sit in the room with me, because I'm only human. I may miss a question or two. I may miss an answer. And this way I'll always turn to that person, whether I'm at trial or a deposition, and say, is there anything I missed? Is there anything else that I need? And you'll get more out of a deposition that way than any other way. And lastly, don't tip your hand in discovery. Because if you send a written interrogatory that specifically requests some information which you know you're going to burn the deponent on, don't do it. Because what happens? The defense lawyer gets a chance to edit and review those answers and phrase it such as a lawyer could phrase it. But if you surprise that witness for the first time, like I did with that Heat player in deposition, with what I knew, he's got no chance to look at his lawyer. He's got no chance to his lawyer to give him tell him how to answer. And all of a sudden, you're getting the truth. Or you're blowing somebody out of the water, or they're going to lie. Either way, you win.
So it really makes sense more often than not to do a videotape deposition for the reasons that, one, we don't always hear everything that's said. We may miss something, whether we're taking notes or we're not taking notes. And second, it's that video picture is not going to lie in front of a judge and jury.
And it's going to present, exactly, it's going to present the demeanor of the witness too. Because you can't get a voice intonation, you can't get a facial expression, you can't get body language through a deposition transcript. And I have learned that body language and a person's facial expressions mean everything. I tell my clients that trials are like plays. And we're going to talk about that when we get to it. But it's important, if your client's going to go to a video deposition, put a video camera in your office when you're preparing them. Film them on video. Teach them to look at the camera when answering the questions, not to look at the person who is asking the questions. And play it back for them. Let them see how they look. teach your witness how to dress. There are often times I will make my client bring their clothes that they're going to wear to deposition or to court to show me in advance. And I can't tell you how many times I have sent my investigator or a secretary or paralegal out with a client to go shopping for clothes to make sure that they're dressed appropriately. I don't judge anybody, but what I tell people is you are being judged by others. So remaining neutral in the way you appear is better than dressing outrageously or trying to make a statement. Because that you never know who's going to look at it, whether you're offending an insurance adjuster, a defense lawyer, a jury, a judge. Why do it? When you're there asking people to compensate you and give you money, try to remain as neutral and as pleasing to as many people as possible. Don't wear a lot of jewelry. Don't have a crazy hairdo. Don't wear loud shirts. Just try to dress conservatively so you don't offend anyone. And it goes a big way. And that's part of a lawyer's job, is to make sure that not only is your client prepared to give the right testimony, but prepared to present he or himself or herself well. And the way to do that is practice. There's no way around it. I get my clients in. I explain to them the following about depositions. I say the deposition is the most important day in your case. And let me tell you why. It's the first time the other side's going to have a chance and an opportunity to hear your story from you. Number one. Number two, it's the first time they get to meet you and see what kind of impression you make. And that's important because insurance companies know that juries like to give money to nice people. And you want this defense lawyer to write back his insurance company, Mr. Smith makes a great impression. A jury's going to like him, as opposed to Mr. Smith comes across as being a jerk, and a jury's not going to like his attitude, his demeanor, or the way he acts. That doesn't help you. I said it's also the first time that they have a court reporter there who's going to take down everything you say. And the reason they do that is because if we do go to trial in the case, and you say something differently at trial, they're going to use your prior statement, your deposition, to impeach you and make you look like you're not telling the truth. And juries want people asking for money to be telling the truth. They don't want to catch you inconsistencies. So we want to make sure your story today is the same it's going to be at trial. There are no surprises. There are no changes. And I give them rules. I say, listen to my rules. Number one, listen to the question. If your question is not clear, or if it's confusing, or if you're not at all sure what the question means, you get perfectly acceptable to say to the lawyer, excuse me, can you please rephrase your question or ask it in a different way? I tell them if you can answer yes or no, and shut up. For example, if they say, are you employed? The answer is yes. Don't tell them, oh yeah, I do this, and I work for... Let them ask the question, and if they're not bright enough to ask it, that's their problem. If you're not sure of something, or if you don't remember, I want you to say you're not sure or don't remember. It's perfectly acceptable. It is not a memory test. And don't guess under any circumstances, because if you guess and you guess wrong, we're stuck with that answer. I tell them to be very careful about time and distance, because most people are terrible judges of time and distance. As a young lawyer, I had a lady who was stopped at a traffic light, and she was rear-ended. I'll never forget this. An defense lawyer says, ma'am, how long were you stopped at this light before you were struck in the rear? 10 minutes. Well, there isn't a traffic light in this country that's functioning that lasts for 10 minutes. So what I tell people to do is tell the truth. I'm not a very good judge of time and distance. It was a short period of time. And defense lawyers then will say, well, was it more than 10 seconds? Was it less than 10 seconds? I said, don't get into that game. Don't let them intimidate you into giving them an answer that they want. You stick with your story because it's the truth. You're not very good at it. You were stopped. You know you were stopped. You've been there for a short time. You can't tell if it's 5 seconds, 20 seconds, 15 seconds. That's when you were hit. And that's the end of it. Don't get caught making answers up because you think somebody else wants to hear it. Tell the truth and don't guess. So those are the ground rules. And then what I do with people is I start playing defense lawyer. Or I call my partner in to play defense lawyer. And we'll ask them the questions, and we'll have them answer it. And if it's on video, we'll video it. And if their answers aren't succinct, we'll go back and we'll redo it again. And we don't want to make it out to be a script or a play or anything like that. We just want the people to feel comfortable. We tell our clients that they're not prisoners in a deposition. They have the right to take a break anytime they like. They can get up, stretch their legs, get food, go to the restroom, get a drink of water. Just if they want to if they feel they've been questioned for too long, then just stop and relax. And if it's not their best day, then let's not do it that day or let's not finish it. The worst thing a client could do, and I hate when I hear this, is saying, I just want to get it over with. A deposition is not something you just want to get over with. You want to be at your best because that is one of the keys to your case as a plaintiff. So tell your client, be prepared to invest the time, invest the preparation. Make sure they have answers to the discovery that they've given. Have them review their answers to interrogatories. Have them review certain documents or photographs that you think are going to come up into play. Make sure that their answers are going to be consistent. That's all very important. Make sure that in advance of the deposition, you tell them, make a list. Talk to your wife. Talk to your children. Talk to your employers. Make sure that you know what it is that you can't do at all and what it is that you're limited in doing. Activities of daily living are super important in personal injury cases. If you can't reach above your head because of a shoulder injury, that means that you can't put away certain things in cabinets in the kitchen. You may have trouble brushing your hair. You may have trouble blow drying your hair. You may have trouble putting away clothes on a hanger on a higher spot in your closet. All sorts of things. These are things we want you to be able to tell in a deposition because it makes you human. Everybody in your life has pain. Everybody in their life has limitations. The whole point in a personal injury case is to get across the fact that but for this negligence of another driver, a property owner, a doctor, a product manufacturer, someone, that you wouldn't have these problems, that you'd be living more of a life that you lived beforehand. And the other thing is pain. Nobody can take a picture of pain. You have to be able to describe the pain that you're in. And you have to describe it accurately without exaggerating it. Clients will tell me, my hand is numb. Now, I know they've got a herniated disc in their neck. I know that that's pinching on a nerve, but I also know that there are 3 nerves that service the hand, and that the probability of their whole hand being numb because of a pinched nerve in their neck or a disc pinching on a nerve is minimal. And I'll say to them, let me ask you this. Is it really your whole hand? Because that's just the way you're speaking. Could you specify what fingers? And most times, they're going to say, yes, my little finger and my ring finger. And I'll say, well, that makes more sense because that's a distribution of a certain nerve root. And I have a chart in my office with the distributions of nerve roots. And I show them the chart and I explain to them why it's important that they're specific. If they have pain down their leg, don't just tell the doctor you have pain down their leg. Show them where it is on your leg because that relates to a nerve root. And part of the job as a lawyer is you better understand the medicine that you're talking about. Buy the books. Get the diagrams. When you conference with the doctors, ask them to explain it to you. And when you're taking depositions or you're talking to juries, don't speak in medical terms. Speak as normal people speak. You know, you could say there's a comminuted fracture. You could just say they have a broken bone in several pieces. What plays better to a jury? Or if your doctor is going on and using medical terms, there's nothing wrong with stopping and saying, doctor, could you explain that in layman's terms so we could all understand it? And have them explain it and show it in a picture or in a model or something like that.
It goes back to communication. It's not what we say, it's really how they hear it. And the other thing I'm hearing, and I think that the attorneys out there who aren't using videotape deposition at this point would probably be interested in is what is the difference in cost. Obviously, there's a huge upside to using the videotape deposition, especially if you do have a patient, a client who's demonstrating pain. That might even show up when they're videotaping and you're asking questions.
I'm not advocating the use of video depositions in every case. I'm advocating the use of video depositions in cases which warrant their use because of either tough liability situations or big damages on your part where spending the extra $300 to $500 for the video is well worth it. There are economic choices which have to be made, and you have to look at what the value of the case is, what the coverage is, and everything else before you make those decisions. But I see more and more defendants using video depositions on plaintiffs, and I use them more and more in my larger cases because I find they're an invaluable tool. So there's no rule of thumb. If you have a question and you're not sure whether to use it, speak to someone who's more experienced. Get their advice. But when you do it, here's another trick. Stand behind the videographer and look through the lens or the screen on that camera to see how the witness is being portrayed. If it's your witness, you may want to ask him or have your witness look more at the camera. If it's the defendant's witness, you may want to be closer or you may want to be further back. And if you're showing photographs on video, you've got to make sure that that photograph is held up long enough for the videographer to focus in on it and for the witness to point out everything on that photograph that's important. Because just by holding up a picture doesn't mean that the people viewing it later on can see it. So make sure that the videographer has the opportunity to focus on it, get it clear on the screen, and that what you want to show is clearly demonstrable.
That's a great point, because you want to see what's going on as you're doing it and before you shoot the video, as opposed to seeing it after you've spent the money and you didn't get the results that you'd really want to see.
You're going to hear from me, and I'll tell this to my clients time and time again, a lawyer is like a director of a play. You choreograph and direct every part of your case from the moment you sign it up to the moment the jury returns a verdict. And you have to be on top of every aspect of that case in order to get a great result. But we'll talk about that more when it comes to trial preparation.
So we're talking about some of the video depositions and preparing your witnesses. Obviously, is so important. Let's talk about the defense medical examination and preparing your own client for their own doctor visits. Now, I know we touched on speaking to the doctor, so you have a good read on how the doctor's going to talk. Let's talk a little bit about the client.
It's very important for the client when they go to the doctor to be prepared. And what I mean by that is to really have in their mind or have written down on a piece of paper what it is that's bothering them, and to make sure that they tell that to the doctor, that they're clear in their complaints, that they understand that they need to tell this doctor everything from the top of their head to the bottom of their toes, whether or not he's listening, whether or not he's treating them for it or anything else. And to ask the doctor, doctor, is my headache related to this, or should I see someone else for my headache or whatever else? And to make sure that they follow the doctor's instructions, whether it's taking medication, whether it's going for therapy, or anything else. Clients will often call me and say, well, the doctor's talking about surgery, what do I do? It's a very hard question for a lawyer. Certainly surgery increases the value of a case, but at the same time, you're not a doctor, and surgeries have certain risks. So what I always tell a client is, listen, you need to talk to your doctor. You probably want to go get a second opinion. You need to listen to the doctor, take a family member with you, or someone you respect with you, and you have to make the decision. But if you're saying to yourself, you know what, I don't want to have the surgery today, but in a year or two I'm probably going to have it, I said, then you got to think about it in terms of your case, because the surgery will increase the value of your case. If you're going to have it anyway, you might as well do it before you close out your case. If you're never going to have it, then that's fine. tell the doctor the reason. If you're afraid of surgery, if you're afraid of anesthesia, if you want to try the conservative means, I as a lawyer can live with whatever decisions my clients make. I just want them to be informed of the ramifications of their decisions on their case. And I think that's part of the job as a lawyer, to let the client know what all that means. And my clients have appreciated my telling them and being honest, because they are then empowered to make the choice as to what they want to do with their health and their body. Now, aside from going to the doctors, you got to make sure that the clients follow up, because sometimes cases take some time, and after a number of months the doctors may say, well, you're as good as you're going to get. You've reached maximum medical improvement, and come back and see me if you have any problems. Client's going to go home. You as a lawyer are going to get the report from the doctor. You may make a demand. The case may not settle, and you're in litigation. And what happens if you're in litigation for a year and your client hasn't been back to a doctor and has no complaints? The first thing the insurance company lawyer is going to argue is, ladies and gentlemen, if this client's hurt so bad, this patient's hurt so bad, why hasn't he gone back to a doctor in a year? You need to impress upon your client the fact that they need to go back periodically and complain to their doctors about any problems they're having. Even though the doctor may say, there's nothing more I could do for you, or he may say, let's try this, or let's try that, or let me send you to another specialist. But if you don't go back, you're hurting your case. And you're not doing your job as a lawyer if you're not making sure that these clients are going back to their doctors as patients and complaining. Because doctors are not going to call them up and say, hey, you need to come back and see me. It's your job to get the clients to go back there. And many lawyers don't do that, and that's a big problem. And it just winds up costing in the long run.
It goes back to the follow-up of the case and the case management. And if you're on top of it, you've got it in your computer ready where your staff can then be proactive, calling up the client and saying, hey, have you checked in with Dr. Smith lately?
That's one of the reasons we send letters out every quarter to clients about what's going on in their lives and to keep us informed. If a client, if I'm representing someone for an automobile accident and they then have an appendectomy, I still want to know about it because I want to get those records. If they went to their gynecologist for an exam, I want to see those records because the defense will get those records. And I'll tell my clients, I don't care what doctor you go to see for what reason, even if it's unrelated, you tell them everything that hurts you and is bothering you. Because in that hospital chart or doctor's record that's unrelated to this accident, they're going to ask for a patient history. And they're going to ask for complaints. And you would like it in there if your neck hurts, patient complaints of neck pain. Now, you may not be there for the neck pain, but I'd like it in that note to show that it's consistent. My staff, every month, my computer system requires every file to be touched every month. And that don't just mean by picked up and handled. I mean physically worked on and moved. And the diary system that your case management system, which we talked about earlier, has, is critical in that. I could pull up any file at any time from my desktop and see the to-dos. What's done, what hasn't been done, when was the last time a file was touched, and it gets red flagged. And if an office staff member doesn't follow up on something, I have the recourse to say, hey, you didn't do this, get it done. And they will. Creates a big difference in the way clients perceive the firm, your results, and everything else.
So we talked about the consistency and how you handle the case, but let's talk a little bit about how you deal with the clients who aren't consistent in their treatment, in explaining. I know it sometimes is a difficult position for an attorney to be having that discussion, but obviously it affects the case in a big way.
You have to document your file. You've got to get these people in to see you if you can. You have to go out to get to see them. You've got to send them letters. At times you're going to throw up your hands and say, okay, this is the best we could do, and at times you're going to say, you know what, I don't want to be your lawyer anymore. It's an individual decision on an individual case basis, and any lawyer that's done this long enough has had all those things happen to them. And it's a sad day, but it's a day when sometimes you have to just cut the umbilical cord and say, I've done everything I can for this client. They're self-destructive. They're not helping themselves. I'm spending good money after bad. I know they're not going to be happy with the result I'm going to get. It's time for me to cut my losses and get out. And that happens to all of us. And you try to keep that at a minimum because it costs you money.
Can you give us an example when you learned your first lesson about putting your time in and the consistency with the client, not only going to the doctor, but following up with the instructions that you've laid out when you've choreographed that case?
I'll never forget a case where I represented someone who had a significant injury, but they just didn't like doctors. They wouldn't go even though they had appointments made by the doctors. They didn't follow up on any of the prescribed therapies or treatments. And they were out there, I'll never forget this one young man, riding a jet ski, knowing that it was the worst thing in the world that he could do, jumping waves. And I looked at him and said, there's nothing I could do for you because I could probably only settle this case for a small amount of money. You're not going to be happy. You think you've got this injury worth hundreds of thousands of dollars, but your actions and the way you're behaving just don't justify it. So instead of disappointing you, instead of you getting mad at me, instead of your getting a bad result, I'm going to withdraw from your case and go get another lawyer, and good luck. Sometimes you've got to do that. It doesn't happen often, but sometimes you need to protect yourself, and you need to protect your client from themselves. And you can only do so much. You're not there all the time. One of the things that you have to also start thinking about during your trial is how best to present your client, your case preparation, how best to present your client to a jury. And depending upon the case, you may want to consider something called a day in the life video. I tell my clients, you've lived with your pain, or a family member has lived with your pain, your disability, your impairment. I've lived with you, but the people that try in your case, the citizens of this community, don't know anything about you, don't know how it affects your life. So sometimes when clients have severe limitations, we'll pay a video crew to go out and really film what an average day in their life looks like. How hard it is for them to get out of bed, how hard it is for them to get dressed, to get in and out of a car if they can, what their life looks like on a daily basis, because a picture sometimes is worth 1,000 words. I recently represented a man who was a recent immigrant to this country, was delivering coffee to a large office building in downtown Miami, and through no fault of his own walked through a doorway. A 200-pound door fell on his head. Just fell off the hinges on his head. Knocked him to the floor, knocked out a couple of teeth. He was rushed to the hospital. And as more often than not happens, the CT scans of the brain were normal, the MRIs were normal. But according to his treating physicians, he had a mild traumatic brain injury. And mild traumatic brain injuries, as the literature will tell you, are not always demonstrable on CT scans and MRIs. They're just not. You need sophisticated neuropsychological testing. And you also need to understand who the person was before, talk to his family, his friends, see if his personality has changed, his actions have changed. The thing that won that case for us, and won it big, was not only talking to his family and friends and getting to learn about the man and his behavior beforehand, but I always ask for pictures of my client and videotapes of my client in the days and years before their injury. And when you held up a picture of this man taken 6 weeks before his accident and what he's like today, it was two different people. And we had a whole show put together of what this he was smiling, he was happy, he interacted with other people before the accident compared to afterwards, when he was a recluse, he was unkempt, he had no memory, he had no smile, he had no sparkle in his eye. So it really didn't matter at that point what the scan showed or what the doctor said. It mattered what the evidence showed through the pictures and through the testimony, the people that knew him best. And it's an important lesson to learn that ask your clients about their lives. Go visit them in their homes if you have a catastrophic case. People don't realize how they change their life after an accident. I'll often say to our client, the mind is a wonderful thing. We forget the horrible pain we're in a short period of time. We learn to adapt because of limitations that we have. I said, unfortunately, depositions, trials make you remember those things. And I hate to put clients in that position where they have to remember, but that's my job as a lawyer. But I ask them to keep diaries, to write down what happens. I ask their spouses or children or other loved ones to keep diaries, because they forget that they couldn't go to this wedding because they were in pain, that they went to this party but they couldn't dance with their wife because they were in a cast, that they couldn't go to their son or daughter's graduation or their Little League game, or they can't play catch anymore with their son, or go fishing or go out on the boat, and do all the things that every day that we take for granted. And that's what life's all about. You've got to humanize the client. You've got to make the insurance adjusters, the defense lawyers, the jurors understand how this injury has affected this person and this family.
So we touched on a little bit now on the choreographing of the case and going through the day in the life. So let's talk about, when you're choreographing that case and your use of your presentation materials, such as medical illustrations. You touched a little bit on spinal models, etc. Where do you go about gathering that information or putting together your medical illustrations, and how do you go about putting together your presentation materials?
One of the things, we do a couple of things. Number one is we work with a particular company here in Miami, and they work all over the country, that does PowerPoint presentations, illustrations, accident reconstructions, things of that nature.
And what's the name of that company for our audience, so they may be able to use them, if that's okay?
I'll ask their permission and get it for you. But I'm sure it'll be okay, or people could call me and I'll be happy to give it to them on that basis. Great. And what they'll do is they'll meet with the experts, they'll meet with the doctors, they'll have everything approved. The same thing for our illustration. Sometimes we want a board to show an injury, and we've got a certified medical illustrator who takes the x-rays, and he goes out and meets with the doctors and say, is this an accurate depiction of what injury this patient presented with, and is this an accurate depiction of what you did surgically to repair it? And once they have approval, they put it on board and it's all colored. Think of an x-ray. We've all seen x-rays. You look at them, they're okay. I mean, maybe you could see a break in a bone, but most of us can't read cartilage or brain x-rays or other damages. But when you draw that anatomically correct with color, and you show bleeding, and you show fractures and fragments, and you show surgical screws and plates and hardware, it makes the world a difference. And then you ask the doctor to describe, well, doctor, you put a plate in this man's shoulder. Tell me, what instruments did you use to do this? Well, I used a chisel, and I used a drill, and I used a screwdriver, and I used wire. Well, it becomes more like a carpenter than someone, if you think about it, as a surgeon, because most people don't think of surgeons as using those type of hand tools and can't even imagine having somebody drill into their shoulder or use a chisel to cut a piece of bone. And that graphic detail means hundreds of thousands of dollars in an award, which is what you're trying to do, maximize the award. You're not lying, you're telling the truth. You're educating the jury, you're educating the insurance company, and you're educating yourself at the same time. So all of that is very important. And I like exhibits. I like hands-on things. I think the way people watch TV today and they watch these court cases, they're used to high technology. They're used to things being described to them. Words are wonderful, but pictures and exhibits and things you can hold in your hand and play with, I'll order surgical screws. I mean, I've had clients that have had 6 screws put into their shoulder. You look at an x-ray, you see what looks like a screw. Even look at a medical illustration, you see it colored, it looks like a screw. But when you hold up that 4-inch piece of screw in your hand as a juror, and you pass it one to another, it's a whole different impact.
So it's kind of like almost that CSI mentality that people and jurors have been seeing so much on TV that they're really expecting to see that from you also.
Absolutely. I believe that CSI has changed the whole way we have to practice and present cases, as well as some of the other TV programs. And when we get to trial, I'll talk about voir dire and why it's important to question people on what they watch, what they read, and what they believe.
Okay. Stuart, can you tell me a little bit about your relationship with the defense lawyers when you're litigating a case?
Absolutely, and I think it's one of the most important aspects of litigation. I have a firm policy and belief that it's important to be a gentleman or a lady in litigating a case, and that what goes around comes around. If a lawyer asks me for an extension of time, if they ask me for some certain consideration, it's rare that I'll ever say no, because I understand that they have other cases, they have personal issues, they have family problems, etc. And I believe you get more with honey than you do with spice. And I would say the vast majority, well over 90% of the cases I have, I get along great with the defense attorneys. You know, I don't mind if we're traveling, and I look forward to, saying to them, listen, this is the hotel I'm staying at. Why don't we stay at the same hotel? We'll share a cab. We'll go out for dinner. And not necessarily even talk about the case, but just develop a personal relationship of some trust and some belief. Some lawyers you can't do that with, and you'll learn that. I try to avoid filing motions. I'll call the defense attorney on the phone and say, look, you owe me discovery. I don't want to file a motion. When can I get it from you? How can we work this out? Or you're objecting, saying I didn't give you good enough answers. What more do you need from me to help you? And then that's a key. What I try to do with the defense lawyers from the beginning, whether it's somebody I know or somebody I don't know, is understand that they have a job to do. They have people to report to. They have people in their own firms and also insurance company representatives to report to. And I want to make their job easier. So I'll say to them, what can I do? What do you need from me to make your life easier, to help you defend this case and get this case to the posture where you need to have it so we can get it resolved? And more often than not, they'll say to me, well, if you get me this report, or if you get me this MRI scan, or if you could explain to me how you figured the economic damages, that'll help me. And I find that by doing that, the defense lawyer may not always go to bat for me, or she may not go to bat for me, but at the same time, they're not going to take the position with the adjuster that, hey, Stuart's a jerk and let's not pay him any money. They may be neutral, or they may be kind of friendly. But why create an enemy when you don't really need to? Certain circumstances, it happens. You're just dealing with somebody on the other side who's just impossible to deal with. And when my attitude to them is, guys, I give everybody an equal chance. Once you screw me, twice you screw me, the third time it's over. And I can play hardball with anybody. But there are certain cases I've tried where I've never been in front of the judge until the day of trial. And the judge will look at me and say, wow, you guys really must have worked it out because I haven't seen you here on any motions. And it just makes for a much smoother handling of the case. Be respectful of the other lawyer's time. If they have a vacation planned, if they have something they have to do for their kids, if they have problems, with other cases they have, if you could accommodate them, I would do it. It doesn't really hurt you and usually helps you in the long run.
So it's the same philosophy that you have about your relationship with the defense attorneys as you have with the claims adjusters. It just makes your case go a lot smoother.
It really does. Even though we are in an adversarial environment, there's no reason to be antagonistic. You could be an adversary, but you could be a gentleman or a lady. And I think you're better off being nice than being an arrogant son of a gun.
Certainly it's going to help your case get completed or come to whatever fruition settlement it's going to come to a little bit sooner.
In 31 years, I found that to be the case. I found that if somebody wants to deal with me in a case and offer me money, I'm not going to be insulted, even if it's a very low offer. They're offering me money. It doesn't mean I'll respect them for it. I'll thank them. I'll thank them for taking the time to make a trip to visit with me, to talk to me. But at the same time, it gives me a chance to reinforce my own beliefs and tell them why I think they're wrong. And I think they'll listen to me more if we have that cordial relationship, as opposed to my jumping up and down and screaming, "You're wrong, you're an idiot, you're not evaluating the case properly," because that turns people off. And the whole job of a lawyer, of a trial lawyer, is persuasion. And we have to learn how to persuade people that we're right, or even if we're not right, that other people may perceive us as being right, and therefore give our clients a large reward. And that's what we have to get across to the defense attorneys, that yes, you have your point, I have my point, but what is a reasonable jury going to consider and do? And if you could do that and accomplish that, you'll settle most of your cases. So you do want to come across as being somebody that the other side could work with. You want that reputation in the community. You don't want to come across as being an unfair litigator. People want to know you're tough. People want to know that you will do whatever is necessary within the bounds of ethics and the law to represent your client, but you're going to do it like a gentleman or like a lady.
The CLE code for this disc is PIE 4810. This program continues on the next disc.